Well, estate succession planning is a key factor of any ag operation. And if it doesn't get accomplished before death, well, issues can arise when trying to pass the farm down to the next generation. Well, Roger McEowen with the Washburn University School of Law joins us now for a further look in today's Rural Money segment. Roger, as always, thanks for your time here today. Let's start with some of the main elements, of course, that we need to keep in mind when farmland is then partitioned off and then sold.
Yeah, well, Janet, partition and sale of land is a legal remedy that's available if the co-owners can't agree on whether to buy out one or more of the co-owners or sell the property and split the proceeds. And it's often the result of a poorly planned farm or ranch estate where the last of the parents to die leaves the farm or ranch equally to all the kids, and not all of them want to farm or they simply can't get along. It's just a judicial procedure where we're going to sort out who owns what simply because mom and dad didn't do the appropriate planning.
So what are the tax consequences, of course, of a partition and the resulting sale, and how do you maybe head it off?
Yeah, this is actually one thing that's good about this. You kind of luck out on this. So long as avoidance of tax is not deemed to be by the IRS a primary purpose of the transaction, then a partition and sale amongst all the same owners, if we're just splitting the property up and dividing the tracts up amongst the same co-owners, then that doesn't trigger gain for the purchasing co-owners as to the co-owner's interest in that property. So it's a non-tax event.
Is a partition considered to be an exchange?
No, it's not an exchange either. It's just a severance of that joint ownership. And that's why there's no tax unless there's a mortgage on the property or there's a tract that's received that is materially different than the other tract. But if we're taking a bare, say, section of land and splitting it up 4 or 5 ways, and there's no debt on that property after the last mom and dad had died, then there's no tax.
And does it matter if the partition involves a single contiguous tract of land or multiple tracts?
Yeah. No, doesn't matter. It's not a sale or exchange, and it doesn't matter if we have one tract, we have multiple tracts that we're dividing up.
And what would you say, Roger, is the big takeaway that we need to keep in mind?
Well, I think we need to end where we started with, and we can avoid all of this if we do appropriate estate planning during life. So if mom and dad do the appropriate planning to avoid this legal action post-death to sort it out, that's what needs to be done. It's simply often not the best thing to leave farmland to all the kids as co-owners because somebody's going to want to get bought out at some point in time if they don't want to be the farming heir.
Roger, making that move in estate planning can be somewhat intimidating. What is the best first step that you might suggest?
That's a great question. I think the first step is to list out the assets that you own. Sit down, fill out a piece of paper, and summarize your assets and your liabilities, and then kind of list generally what your goals are. So you know what you're dealing with, and you know generally what your goals are. That's a good place to start, and it'll get you involved in the process. If you start out by trying to think about how you want to be fair to all your kids, you're not going to get started. So I would just simply list out assets and liabilities and generally what your goals are, and then start working with your practitioners from that point.
One step at a time. Well, Roger, as always, thank you very much for your insight. Roger McEowen, he's with the Washburn University School of Law, connecting here with us today. Go online to washburnlaw.edu/WALTR for more information. Thanks, Roger.